Court calls the case, People versus Kamu Carter.
Nimish Ganatra for the people.
Good morning, Your Honor. Assistant Public Defender Calvin Hawthorne, appearing with and on behalf of Kamu Carter. Mr. Carter, will you please state your name?
Carter.
Okay, what are we doing?
Your Honor, we have been in discussions with the people to reach a global resolution. However, we are still awaiting new charges to be authorized, so we are requesting a 2-week adjournment.
2 weeks? 2 or 3? His other case, the other case before me that I think is all part of this, I can't recall what date I gave from my other docket, but
It was the second, Your Honor.
the 7th? That's
So
what I
second.
thought. Second.
Yes.
Okay, I could set it for the 3rd if you think you'll wrap it up, or I could set this for the 10th. Either way, what do you want me to do?
Let's go with the 10th, Mr. Ganatra. Is that
All right.
Your Honor, I do have
Hang
one
on a second.
request.
Hang on 1 second.
One's on the second, one's on final settlement on the 11th.
Okay. He also has, if you're looking for a global resolution, he's got one before me on the 2nd. He also has another that's set for final settlement conference before me on the 11th. So, all right. And we'll try to figure out a date. Yes, Mr. Ganatra, you were saying something, sir.
Your Honor, I wanted to bring to the court's attention, you're aware of the child abuse case and the domestic violence case, because both of those matters are being prosecuted by my colleague, Caitlin Kirby, in your court.
Yes.
Ms. Kirby informed me yesterday afternoon that the defendant is still having phone calls with the victim on the DV case, telling her not to come to court and appear. At this point, I'm asking for this court to revoke his phone call privileges in the jail on all the cases.
Any response, Mr. Hawthorne?
Your Honor, I would ask that you admonish Mr. Carter to refrain from making any calls to the victim and allow him to make calls to our office for legal purposes.
All right. Here's what I'm going to do. Hey, with regard to the probable cause conference, I'm going to set this one right in between that. I'm going to adjourn this out to August 10th, 2023 at 9 a.m. With reference, so his bond on this will continue with reference to his phone privileges. You got it. I'll certainly have a hearing on it if, Mr. Hawthorne, you think it's required, but in the interim, because of the nature of the other 2 cases that I'm familiar with, I am going to revoke the defendant's phone privileges. If you wish to request a hearing on that, you may, but at this point, his phone privileges are hereby revoked. Right. Thank you.
Listen.
Court calls the case, People versus Joshua Snyder.
Good morning, Your Honor. Maria Rosinski on behalf of the people, seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Laura Willenbring.
I hear that in my sleep. Permission to practice is granted.
Thank you.
Good morning. All right.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Snyder, on behalf of Joshua Snyder.
Joshua Snyder, state your name, please.
Joshua Snyder here for the record.
Thank you. All right, what are we doing?
Your Honor, I have discussed this matter with Ms. Willenbring and Joshua Snyder. There's some matters in the circuit court. I believe there's no pending offer here, but we'd like to waive Joshua Snyder would like to waive the preliminary examination and see if we can't do something globally in the circuit court.
Got it. My up judge is Slay. Is that a correct statement?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, Defendant is bound over to circuit court on counts 1, 2, 3 with 4 following. Mr. Gaddy.
Your Honor, in terms of arraignment on the information, we'd waive reading, stand mute, ask for a pretrial to be set.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 4 counts. Pretrial will be set for
August 28th at 1:30 with Judge Slay.
August 28, 2023, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bond will continue.
Your Honor, if I could be heard briefly on bond.
You may.
He has a personal bond right now. He's being held in the circuit court matters. Joshua Snyder is being held in the circuit court matters, I believe on remand. If we could have a nominal bond in this matter with a release to treatment, which is what Judge Slay had ordered on the other one, perhaps he would be acquiring time. I think he's been in 90 days, it looks like, waiting here without credit.
Reduce the bond in this case. I'll make it a 5,000, 10% bond. As to the release to treatment, now that this case has gone up to Judge Slay, that can all be done at once at that point. Because it'll be her case.
I believe she's ordered it on the probation matters, Judge. I just don't want this matter between now and August to prohibit Joshua from going to treatment.
Maybe released to treatment on PR.
Thank you, Judge.
Kevin Callahan for plaintiff, P78273. I have with me the owner of the property, Abreet Kaur.
Good morning,
And
Your
this
Honor.
is
Robert.
go ahead.
I'm sorry, Your Honor. Good morning, Robert Bill here, Your Honor.
All right. Counsel, did you receive a copy of the answer?
We received a copy of the answer by email at 4:36 last night. It's my understanding from our last court date that Mr. Beal indicated that he was having his lawyer appear. No lawyer has appeared on the case. He was required to tender $10,000 into the court's escrow by the 10th of July. I don't have evidence of that. Not to say that it didn't happen. I don't have evidence of it. And he was required to answer the complaint by the 10th of July. And we just received the answer last night that poses 0 legal defenses, Judge.
Mr. Beal, do you have an attorney here?
No, Steve Wallace will be hired as of next week. The reason I did not put the escrow in Monday as you required me to and give the answer, my business partner had a stroke in Oregon. I flew to Oregon and I just got back Thursday night. And my wife has already took the funds out the account. I didn't want her to take that a lot of money up there by herself. So I told her I'll start working on that after I speak with you today. But we have all of the rent money.
That escrow was supposed to be in.
Yes, Your Honor, you're right.
Oh, I know. And all right. And the answer was supposed to be in earlier than it is now. And I don't see where you're indicating that any defenses to the amount they're claiming is owed.
The amount they're claiming is owed, we're off a few $1,000s, but not the majority of the rent. The majority of the rent of the $4,500 is definitely due. I have been going back and forth with the management company to do some things around the house, and they have yet to do everything. But the key thing was the deck and the security of the deck. They told me we were going to put a deck up. They decided not to. I asked them to let me pay for the deck. They said, well, you pay for it. We're not going to reimburse you for it. I said, well, what about if I sell it to you back at 30% after I leave, after the lease is up? They said, no. I said, well, if I pay for the debt, can I take it with me when I leave? They said, no. So I have been trying back and forth to go back and forth with them to try to work out an agreement with the deck. I did speak with the county yesterday. Steve, the inspector, and he said by law, they're not required to put a deck up, but they are required to have a security barrier back there. So Steve said he was going to call, Steve, the inspector for the county, said he was going to call email the owner to see if they can arrange to put a barrier up. Once that barrier is up, I'm fine. I don't have a problem.
How much is owing on this account?
With court costs, Judge, it's $18,944.23. Court costs are $235.
Here's what I'm going to do in this case is I'm going to, the escrow needs to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises. There's some excuse, and you're just going to have to put up or not. I mean, I ordered 10,000 in escrow. You said you were going to pay it. I get here today. You didn't do it. I don't have any proof of what are the other things that you're talking about. Don't need it, quite frankly. You were supposed to put the 10,000 into escrow. So, if the escrow is, so I will grant the judgment. If the escrow is paid, then the judgment will not enter. It needs to be paid today. If the escrow is paid today by close of business, then this matter adjourns out to July 21st, 2023 at what time? At 10 a.m. So the escrow needs to get there. If it's not here today, plaintiff's entitled to their judgment for their full amount. If it's there today, then I'll see you guys next week at 10.
Judge, if I may.
I make my orders, you got to follow.
Judge, if I may respond.
Pardon?
If I may respond to that, Judge.
Sure.
Judge, there's absolutely zero reason for us to adjourn this again. Mr. Beal,
Counsel,
if I could.
That is what I'm doing. I don't need a response from you. That is what I'm doing.
Judge, I would like to make a record if I could.
I go for it.
Thank you, Judge. At the second court date, we received a possession judgment for the full amount. Mr. Beal was not present. Mr. Beal decided to come later on, and the court set aside that judgment. At the subsequent hearing, Mr. Beal made promises to this court, made promises to us that he has a lawyer, he has the escrow, he has this, he has that. He didn't do anything he was required to, and there's zero legal defenses here. I don't understand why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about,
are you done? Are you done?
I'm not done. No, Judge. I'm trying to make my argument for the record.
Get done.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about a deck is between the owner and the city and has nothing to do with the legal contract and has nothing to do with Mr. Beal's obligation to tender rent. I have an owner here that has been displaced from her house. She's owed over $18,000 and is not receiving a single dime here. I don't know why you're giving Mr. Beal another opportunity when there's absolutely zero legal defenses.
All right. First of all, part of your record is wrong. And absolutely wrong, because that was explained to you the last time. So don't try to distort the record, counsel. The reason that the judgment was set aside is Mr. Beal was attempting to try to get in. We verified it. In deference to somebody trying to sign into Zoom, I set aside the judgment. I explained that to you. So don't try to distort what happened. Second thing, I told Mr. Beal this is what he needed to do. He has given me some reason why he did not do it. Certainly, I question whether or not all of that occurred. But what I did is I said, look, if you were to put the escrow in, he files the answer, we'd have to deal with that anyway. He's saying there's a reason why he didn't put the escrow in. I'm giving him till today to get the escrow in. If the escrow's not in, you get your judgment. It's as simple as that. That's why that's happening. I'm done. Case over. We'll see you next week or not.